2, 1. Thank you so much for being here. Welcome to another episode of the Empowered Immigrant Live. My name is Otis Landerholm. I'm a certified specialist in immigration law. I'm also the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. And thank you. You know, whether you're tuning in right now on YouTube or Facebook, LinkedIn, Instagram, TikTok, like really, thank you so much for being here. Welcome to the Empowered Immigrant Live, and I appreciate you being here. Okay, so my topic today is I want to go over some of the key changes in immigration law in Trump's first week. Okay, and so thank you for tuning in for that, and I'll go through them. Remember that the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. All right? Today our theme is the key changes in Trump's first week. And so let's go through that. And as I go through that, if you have questions, feel free to submit your questions. I will do my best to answer them all right here live. And so yeah, I'll do my best. Okay? My question for everybody is, you know, lots of changes are happening. Are you ready for them? Do you want to figure out what's the best strategy? What's the best game plan? What's the best options? What's the best way to resolve whatever immigration situation you have so that you can get this immigration issue behind you and you can move on with your life? All right? That's what, you know, our firm is on a mission to win 10,000 immigration cases in the next 10 years. And we would love for your case to be one of them. If we can help you in any way with your immigration situation, we're here to help. We'd love to help. Okay? So thanks for being here. The news, you know, it's the end of January. Well, it's January 23rd is the day I'm filming this. Trump is back in office as of this week. The Laken-Riley Act is close to passing, okay, which is not good for immigrants. It's really not, it's specifically really not good for immigrants who have ever been arrested, okay? And so it makes many immigrants, even with small arrests, and arrests, not convictions, right? Even if you're not found guilty, just the fact that you were arrested, according to this act, will make many people subject to mandatory detention, which is really not good, okay? And so that's happening. We'll be tracking that. I'll do a much more substantive training on that if and when that law actually comes into effect, all right? And we've got ICE talking about mass deportation efforts. There's rumors that some of that will include resuming ICE raids at work, all right? And so got to be mindful of that. You got to be prepared. You got to know your rights, etc. And I'm going to go into the various changes that have happened so far this week. But before I get into all of that, I do want to share something positive, okay? I want to share something positive. You know, we won a case yesterday. I had a client with a tough case. He had an old deportation order against him, all right? He had old crimes where he had been arrested, even convicted of old crimes, and I helped him file for citizenship because under the statute he was eligible, but it was also a risky case, all right? The client knew that he could have been detained. He knew he could have been put into deportation proceedings. And we had a strategy prepared just in case that happened, and the client wanted to give it a try. He's tired of being, you know, he's got a green card for years. He's tired of being pulled into secondary inspection every time he travels back into the United States. Tired of living kind of in limbo. He wanted to apply for citizenship. Okay? So yesterday, we went into his appointment. This was in San Francisco, under the Trump administration. All right? We argued his case, and his case got approved. We won. All right? And I wanted you to know that. And to that client, if you're listening right now, and to your wife, if you're listening right now, huge congratulations to you. Okay? Like, it is possible to win cases. You know, our firm also won a E42B case, a cancellation of removal case, in immigration court on Tuesday under the new Trump administration, right? Like, it is possible to win cases, even with difficult issues from the past. Not easy, not guaranteeable, but possible. And you got to know that, you know, there are going to be cases that are difficult. Some cases might be so difficult it's not worth taking, it's not worth trying. But there are cases where they're difficult, but they're winnable, all right? And you got to be aware of that. And yes, they might have, and they might face more scrutiny as time goes on. We'll be tracking that, right? That's part of the reason to stay in communication. But you gotta know, all right? You gotta know what's going on. Okay, so now I'm going to get into it, and as I'm getting into the topic, if you've got questions, feel free to ask them. I'll do my best to answer any questions that come up today. Okay, so what are the key changes in Trump's first week? You know, on day one, Trump signed, I counted 46 different executive orders just in his first day. 7 of them had to do with immigration, all right, with issues ranging from crackdown at the border, declaring a national emergency at the border so that the military can be involved to like stop and to like systematically just no longer allow anyone to cross the border without permission. They ended the CBP-1 app. All right, you may have heard a story in the news of a woman who waited for over a year to get her CBP-1 appointment, then went in, finally had her appointment this week, but nope, right? No more appointment, no more CBP-1 app, not allowed to come into the U.S., even though she'd been waiting for months, I think over a year in her situation. All right? There was the Cuba, Haiti, Nicaragua, and Venezuela parole program has been ended. The catch and release program is ended, which means that people who are coming across the border and detained will stay in detention. They will not be released. It's been announced that they're going to be reopening the Remain in Mexico program, the quote-unquote Migrant Protection Protocols program, which has all kinds of due process problems. And I won't go into that too much right now. They've ended the refugee admissions program. They've increased to the full extent possible the expedited removal process. And I'm going to do a separate training about that next week, but that's really bad for due process. In fact, I wanted to share last night, it was effective starting at 6 p.m. Last night, a new memo from Department of Homeland Security. It says this designation is effective at 6 p.m. Eastern Standard Time on Tuesday, January 21st, and it increases expedited removal to its full extent possible, which includes, it says, I designate for expedited removal the following categories of aliens not currently designated. 1, aliens who did not arrive by sea, who are apprehended anywhere in the United States more than 100 air miles from the U.S. international border, and who have been continuously present in the United States for less than 2 years. Okay? Subject to expedited removal. Okay? And people within 100 miles who have been in the U.S. for more than 2 weeks, but less than 2 years. Bottom line is they are expanding expedited removal. So if there are people who have been in the United States for less than 2 years, be cautious, all right? Be cautious, be mindful, know your rights, remain silent, don't open the door, all right? They're going to be looking for people to deport them without allowing them to see an immigration judge. We call this expedited removal, all right? So people who have entered the U.S. less than 2 years ago, they're going to be at risk of this, all right, as of last night at 6 p.m., all right? You got to know. You got to know. All right, some other things, I mean, Anyway, there's lots of other things happening. They've said that the COVID-19 vaccines are no longer required in a green card application process. All right. So there's that, right? So there's many other changes happening inside of these executive orders. There's a lot of different things that we could go into and dissect and really discuss. I'll be doing that in the days and weeks to come. The best way to get access to that information is to please take a moment, subscribe to our channel in YouTube, give us a heart, give us a thumbs up, whatever you want to, so that you can stay in communication and follow our content. And yeah, my name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. Now I'm going to get into your questions. So business mindset, very cool name. All right, I appreciate that. Business mindset, you said USCIS received the I-864 RFE regarding an AOS case 127 days ago and still nothing. What to do? Okay, so your case is probably outside of normal processing times. You always have to check your adjustment of status, right? It's the I-485 that governs processing times, and you've got to check it at your field office, all right, the field office level, to see whether or not it's outside of current processing times. And if so, you have the right to start doing inquiries, right? You can do inquiries to the field office. You can do a congressional inquiry with your congressperson. You can do what's called an ombudsman request with the USCIS ombudsman, right? Those are just some of the ways that our office does it when the government is behind in adjudicating a case. Okay, and so, so talk it over with your lawyer, and if you don't have a lawyer, feel free to reach out to my firm. We'd love to look at that for you and see whether or not your case is really outside of processing times and what we can do about it. Okay, J.D. Arenas, let's see, ¿Es mejor pedir VAWA o asilo? ¿Cómo están las cosas? Okay, is it better to do VAWA or asylum at this moment because of how things are? When you're eligible, do both. Okay? When you're eligible, and what I mean by that is if you were the victim of abuse in a marriage to a U.S. citizen or a green card holding spouse, right, or in an abusive relationship with a qualifying petitioner, right, then apply for VAWA. And if your life is in danger in your home country and you're eligible for asylum, talk it over with a lawyer first. If you really have an asylum case, file for asylum too. The best advice is if you're eligible for two things, do them both. That way you have a plan A and a plan B. One of them might go very slow, the other one might go quicker, and so by the end of the case, if one gets approved, you can always cancel the other one. Okay? That's the way I recommend doing it. Just last week, we filed a case for a woman who had been the victim of domestic violence, and we filed under VAWA and a U visa, both at the same time. All right? There's strategic decisions to make there, right? Sometimes that's the best way to do it because VAWA can give a person a work permit, sometimes at least, quicker than the U visa can. The U visa in her situation would enable her to adjust status in the future, but in her situation, she will not be eligible to get a green card through VAWA. She can just get the first phase of her VAWA approved. So anyway, that's a long answer. The best advice, J.D. Arenas, for your question is talk it over with a lawyer, but if you have a strong case for both of those types of situations, the best advice would be to file both of them, okay? But talk it over with a lawyer first, right? All right, Kiki, I see your question here. Thank you for being here. If an illegal immigrant gets pulled over, should they show their Mexican ID when asked to provide an ID? Well, that's an interesting question. If you get pulled over for driving, you do have to comply, right? Most every state has state laws about the requirement to provide a driver's license. And if you, if you're in a state where you're able to get a driver's license even though you're undocumented, like California, for example, then show your driver's license, all right? And if you're in a state where you don't have a driver's license, then it's like, hey, they could, in theory, some places they will arrest you, right, for driving without a license, which is sometimes a crime under state law. You know, at that point, if you want to show your Mexican ID, right, that's a hard thing to do, because then they could use that against you if they were to, like, get in touch with immigration. My gut feeling there is no, don't, right? If a Mexican ID does not give you the right to drive in the state, then I would say, hey, no, I prefer to not give any ID. I don't have any ID with me. I'm very sorry about that. And if they need to make an arrest or something like that, then so be it, and you can deal with the consequences. For me, that's actually protects you more than, I know that's uncomfortable, but I think that protects your rights better than giving them the evidence they're looking for that you are a national of a different country. Okay? Anyway, I hope that's useful. I hope that's helpful. Musi Wolde, I had a CIMT from 1995 committed within 5 years of entry and a deportable crime of moral turpitude, CIMT, but I got an I-601 waiver and adjusted to LPR status 9 years ago. Am I safe to travel, and what other option do I have from relief and citizenship? Yeah, thank you. Thank you for asking this. We've had cases like this. Sometimes it's unwise to travel. It depends on a lot of different factors, including what specific crime it was. I'm glad that you got an I-601 waiver approved already, and I'm glad that your green card was approved. My best advice, though, would be to review those situations, review those facts very carefully with your lawyer, or if you don't have one, feel free to contact our office. We'd be happy to have a consultation and review those records so that we're giving you precise advice. And I would recommend doing those things before you travel, right? If you're eligible to apply for citizenship, I would recommend applying for citizenship, okay? And that's that. And I would recommend becoming a citizen before you travel. Sometimes, I won't say that necessarily in your case, but many people, it's like, wow, no, become a citizen before you leave the country, because there are some green card holders that travel and on re-entry get detained, right? And you don't want that. Or get your green card taken away and now you got to fight about it in immigration court. I'm not saying that that's the situation for you. I would just say, talk it over with a lawyer. I see your follow-up here. You say, if I was put in removal proceedings, can I use 212H again without appealing to adjust as a standalone waiver, or use my I-601 waiver again for the same crime that was waived? So really, talk it over with a lawyer. You should not have to re-waive a crime that was previously waived. All right, you should not have to re-waive a crime that was previously waived. But if there was any other offense, then you might need to. Okay, and so and it's still wise to talk it over with a lawyer before ever leaving the country in your situation. Okay, Zain Kareem, what about VAWA applications that are prima facie eligible? Are they at risk too, or are they protected? If you have prima facie eligibility under VAWA, I think you're in a much better place than a lot of folks. All right, you're in a much better place. Okay, so are they at risk too? I mean, right now, as of today's date, no. All right, they would have to undo VAWA, yeah, I know what you're saying though. You've got a prima facie eligibility, but not the full approval, right? And so yeah, there might be some, if you have like an arrest, if you have some issue that's bad in your case, then you might be at risk in some way. But I would suggest talking it through with a lawyer. Generally speaking, if you have prima facie determination through VAWA right here, right now, as of today's date at least, my understanding is you are not at risk, okay, right now. And so that might change. I'm filming this on the 23rd of January, 2025. Lots of things can happen. And if you have any arrest or anything that might change that calculus, you would need to talk that through with a lawyer. Okay? All right, Gloria Pacheco, hello. All right, hello. You say, I was brought in at 4 years. I'm now 25. I now have 3 kids. How can I get a work permit? Well, thank you. Thank you for asking that question. You're now 25. You were brought in when you were 4 years old. How can you get a work permit? There is no direct way to do it. Okay? There is no direct option to get a work permit in the United States. All right? The only way to be eligible for a work permit is to apply for something else that you're eligible for, right? So that, depending on your situation, you would need to start with a consultation and see, are you eligible for a U visa? Are you eligible for asylum? Are you eligible for a marriage-based or a family-based immigration case, maybe through one of your children, or maybe through, if you're 25, I don't know how old your children are, they're probably not 21 yet. So children probably would not work, but maybe through a marriage or maybe through some other situation, all right? It's got to be through some other immigration process that then allows a person to request a work permit. Otherwise, you're simply not eligible, right, for one, and an application for a work permit would simply be denied, okay? Let's see here. So Rio Joey, everybody that's tuning in right now, welcome and thank you very much for being here. My name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. Welcome to our episode today of the Empowered Immigrant Live. I'm grateful to each of you for being here with me. All right, we're getting a lot of questions, and I really appreciate all the questions that are coming in. I'm going to do my best. I don't think I'll be able to answer them all at the rate that we're getting them. If you have specific questions about your life or about a loved one, who's either facing immigration enforcement or who's got an immigration court case, or, if there's some other service that you're going to need for your immigration situation, feel free to give our office a call. We're here to help. We'd love to help. Okay? So let's see. 88 Sandra, I see your question here. Let's see. Sorry, I need to back up. I see one slightly earlier. Gada Show. I see your question here. I kind of had skipped over it earlier. I wasn't on deportation, but my case was terminated. I reapplied for a green card. I'm waiting. Do you think I'm one of the victims? I would need to know a lot more. It's good that your case got terminated. That typically means that you're no longer in immigration court. And if you've applied for your green card, that's good. You're in a better situation than a lot of people, and now you're waiting. So, that's all good. The best advice would be to have a lawyer, all right? Be ready to help you and prepare you for your adjustment of status interview, for your green card interview, and have a plan B in case you've got to fight that case in court again. Okay? And so that's my best advice there. And thank you so much for being here. Okay? 88 Sandra, you said, hello. If someone is married to a U.S. citizen and has done taxes as head of household, what happens? Just through that, nothing happens, all right? The question is the person who's married to a U.S. citizen eligible to adjust status through their marriage? Because if you're eligible to adjust status through marriage, file your adjustment of status through your marriage, okay? That's the right answer. The taxes as head of household, don't worry about that, right? Don't worry about that. The tax issue is the least of the concerns. The real concern is, are you eligible to apply for adjustment of status or not? And for that, I would say do a consultation, right? All right, Oscar Hernandez. If a parent is being abused by one of their children, do they qualify for VAWA? Thank you for asking this, all right? We have had more and more cases where this is the reality, and my heart goes out to everybody that's in this situation, okay? If you are a parent and if you have an adult child who's a U.S. citizen, if they are 21 years old or older, and if you're living with them, and if they are being abusive or subjecting you to extreme cruelty, then yes, you can qualify for VAWA, all right? You cannot qualify for VAWA until the child is 21 years old. You might qualify for a U visa though, right, if there's a police report involved, all right? But if you're in that situation, get good advice. Talk it through with an attorney. Feel free to contact our office, and we could walk that through, you know, and really learn more about the specifics of your situation and whether or not you have a case worth applying for. Yeah. All right. So Ray Monti, I see your case here. Will immigrants be granted work permits by the new government? We don't know. That's a good question. Immigrants who aren't eligible for some type of application will not be granted work permits. But immigrants who are eligible for asylum and have filed for asylum, or who are eligible for a U visa, those people right now by law have the right to apply for work permits after a certain amount of time. All right? We're going to see if that goes away or is changed or amended in any way. All right? But as of right now, yes, those folks can still apply for work permits. Okay. So let's see. Elizabeth G., I would love for you to explain. I love you explaining things. Okay, thank you. I've been following you on YouTube. Okay, thank you. All right, thanks for that, Elizabeth. I appreciate that. Zain Kareem, what about VAWA applicants with prima facie? Are they at risk too? Yeah, oh, I answered that one already. Okay, mostly not, unless there's some arrest or some other thing. Like right now, VAWA with prima facie, you're in a good situation. Not as good as having a green card, all right? And not as good as having U.S. citizenship, but that's kind of, you know, but you're right there, right? And so, okay. So Ram Ki-soon, I see you. I'm here with a visa and have overstayed for 6 years now. What can I do? Good question. Thank you for asking that question. You are not alone, all right? You are not alone. Talk to a lawyer to see, are you eligible for asylum? Are you eligible for a U visa? Are you eligible for a family-based case? Are you eligible for something else? And what would be your best game plan? If immigration came and found you and tried to put you into deportation proceedings, what would you apply for if you were in immigration court? All right? Talk those things through with an attorney so that you can be fully prepared. Okay? Executive Services, where are you located? Okay, our office is in Oakland, California. The beautiful city of Oakland, California. I love the city of Oakland. I love the state of California. For immigrants, it is the best place to be. And it does not mean, right? It does not mean, I did a whole episode on the sanctuary policies and things of that nature, right? There will still be immigration enforcement out there, right? But anyway, this is where our office is located, and we do have clients throughout the country, right? We do have clients throughout the 50 states. We have clients who are overseas and processing immigrant visas to enter the United States. And so, but anyway, we do all that out of our office in Oakland, California. Okay. Vivian, can my mom fix documents or have a work permit if I petition her? I am 23. It depends. Vivian, thank you for asking this situation. You know, we have a lot of clients. I meet with people, you know, maybe every day, maybe not quite every day, right, who want to help their parents, right? U.S. citizen, they want to help their parents. And so I'm glad that you want to help your parents. Some people have cases, some people don't, all right? The reality is that the ability to adjust status of a parent depends on your parent's situation. How did they enter the United States? When did they enter the United States? Were they protected by 245I? Meaning, did they have somebody else in their family file a petition for them before April 30th of 2001, and were they physically present in the U.S. before on the date of December 20th, 2000, right? So like that is you know, are they eligible for a U visa? Are they eligible for VAWA? Are they like, we've got to do the analysis of your parents, right? Because the strict answer to your question, Vivian, is that yes, you can petition for her, for your mother, right? But like, yes, you can file the petition for her. The question is always, can your mom use that petition? And that depends on your mom's situation. She might be able to fix her immigration status. She might not. It depends on her. Depends on the records in her case and the situation for her. All right. It's 10:50, folks. Let me take 3 more questions. And I don't know which questions I'm going to take. All right. And then I'm going to start wrapping up. All right. And so, okay, the one, I see your question here. What if you missed your biometric appointment for a work permit? Go to the Application Support Center today. Tell them you missed it. Ask them if they can still take your biometrics. All right, just go. Go right now. All right. Sometimes some application support centers will take you, some will not. All right. And at the bottom of your biometrics notice, there's a process for rescheduling it. Okay. So that's my answer for yours. Musumari Muzodi. All right. I am a resident. All right. I am a U.S. resident. My spouse has an I-130 approved in 2023, but the I-485 was denied. Okay. He was denied. He overstayed his visa. He's waiting for his asylum case to see a judge. Okay, thank you for saying this. We've got to look at why that I-485 was denied. We've got to really look, right? Bring the decision in. Let's do a consultation. Let's figure out why that I-485 was denied, because we got to see if there's a way to fix that. Was it denied in error? What really happened there? There's a reason that I-485 got denied. And, you know, and so, and maybe it just depends on, like, if she overstayed or if your spouse overstayed, then maybe we need to apply for citizenship for you first so that then your spouse can refile his or her adjustment of status, okay? All right. Luis Morales, then Uriel Miramontes, and then XXXCXXX. You're my last 3 questions. All right, congratulations. So, and then I'll share a few more things, and then we'll wrap up. Luis Morales. Hi, I overstayed a visa 13 years. My brother's a U.S. citizen. My sister's a resident. My mom, too, all over 21. What can I do? All right. So there might be more to this question. This is all that I can see right here on the screen. You know, your brother who's a citizen, if your mom is a resident, both of them can petition for you. They can both petition for you, but you will not be able to use those petitions unless you either leave the U.S. or something else happens, change in the law happens. All right? So the petitions through your family, as you've written it here, will not work. They will not work to keep you here in the U.S. long term and to get a green card long term. You've got to find a different way. Have a consultation with an attorney and ask about all the different options. Asylum, U visas, VAWA, marriage-based adjustment of status, other types of adjustment of status, right? Because there's no other way. All right? Okay. Uriel Miramontes de Leon. All right. Is the petty offense exception going to be considered for the Lake and Riley Act that's about to pass? I don't know. I don't know. We've got to see the final version of the bill. That's a great question, right? That's a great question. My understanding, though, is that no, it will not apply. My understanding is that, as written, even people with petty theft offenses, which normally would be subject to the petty offense exception, my understanding, as written, is that even people with a petty theft arrest from the past will be subject to mandatory detention. Okay? And so XXXC, XXXCB, I see you're there. Does shoplifting make you automatically deportable or to be held into detention under the Lake and Riley Act? Yes and no. All right? It doesn't necessarily make you automatically deportable, but according to the Lake and Riley Act, it does make you subject to mandatory detention. All right? Like, how can I say this? Even if you're deportable, you can still apply for options. You can still apply for waivers. You can still apply for example, adjustment of status. But you might need to do it from inside detention. All right? Is that clear? You ask a great question, though. Makes me want to pull out the Immigration Nationality Act. Yep, sometimes I got to pull it out, right? Get the law out. 237 A2. Yeah, so if it's a crime involving, so here's the way it works. To become deportable for a crime involving moral turpitude, it's got to become quote-unquote deportable as opposed to inadmissible, right? So the way you've said this term, right, XXXC, XXXCB, right, does shoplifting make you automatically deportable? No, it does not, okay? Here's the way it works, and there's a difference between deportable and inadmissible, right? It doesn't make you automatically inadmissible either. But the way it works for deportability under Section 237A2, right? Crimes involving moral turpitude. Any alien who, 1, is convicted of a crime involving moral turpitude committed within 5 years of the date of admission and is convicted for a crime for which a sentence of 1 year or longer may be imposed is deportable, right? So we got to look at it, in other words. Not every state's law's petty theft crime will constitute a deportable offense as written in the code, all right? We've got to look at it, folks, and that's the way you do it, right? And so, anyway, wanted to share that. There are other deportability crimes. You know, if you have multiple CIMTs, if you've got an aggravated felony conviction, things of that nature, those things do make you deportable. Controlled substance offenses, for example, make you deportable, okay? Crimes of domestic violence make a person deportable, okay? Moses the Great, all right? Can you apply for a U visa if you are an LPR before you are put into removal as an affirmative application? All right. If you are an LPR, you do not need to apply for a U visa. All right? If you are an LPR, you don't need a visa. Okay? Now, sometimes sometimes there's a strategy that does exist to relinquish your LPR status and to file a U visa. Don't do anything like that without really, I mean, you would have to have no other option at all, right? Your LPR status, your lawful permanent resident status, is gold. You want to preserve it. You want to fight for it. You want to defend it as much as you possibly can. All right? Do not trade that in for a visa. Never. Okay? You want to fight for your green card. Green cards are 1,000,000 times better than visas because they give you permanent residence. Citizenship is 1,000,000 times better than green cards because they can't be taken away. All right? Well, denaturalization aside. I'm not going to get into that right now. All right, everybody, that's my spiel for today. Thank you all so much for being here. I'm at the end of the hour. I've got to wrap up, okay? So lots has been said. Thank you for listening. Trump is back. I want you to be ready for it. You got the right to remain silent. You got the right to not open your door. Please don't, please do remain silent. Please do not open your door. Okay? And talk it over with a lawyer, get help, figure out the right way to do this and to fix this because, whenever possible, you gotta just, it's like we gotta do this. We gotta do this. So that's all I got for today. Thank you all so much for being here. I appreciate each and every one of you. All right? Thank you for being here. My name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. We'll see you next time on our next episode of the Empowered Immigrant Live. Thanks a lot. Take care. Bye-bye.